Hi, and welcome back to the Abraham Watkins Podcast, Episode 3. My name is Geoffrey Adkinson. I'm the Social Media Marketing Manager. I'm here with Mo Aziz, who's been a partner at Abraham Watkins since 2012. Mo, you came originally from Pakistan, moved here from Pakistan, and then decided to be an attorney. What made you move from Pakistan to the United States, and what made you become an attorney?
So, Geoffrey, I moved here to go to law school, and my mission was to become a lawyer, practice in the U.S. I was very intrigued by the legal system in the United States. I took my LSAT in Pakistan and applied to a number of law schools, and got into several all over the country. And the University of Houston Law Center was one that seemed the best fit for me, and also, frankly, affordable to a certain extent. And so that's why I decided to come here in 2001 to go to law school. Interestingly, my interest in litigation was really sparked when, as a teenager, I used to read John Grisham books, and was very engaged by that. I mean, I didn't see any other jurisdiction where you could practice this type of law.
And what made you focus on personal injury?
So I had a finance background. I used to work at PricewaterhouseCoopers, and I always thought I would do something finance related in law. Was initially my thought, and I would be some type of finance related practice. But my first job in a law school, after my first year, I clerked for a firm, a small solo practice that did personal injury work. They did some other litigation work as well. It was all litigation, and some was personal injury. And from the day I started doing it, I just knew that's what I wanted to practice in.
And how did you decide to come to Abraham Watkins?
So, from what I remember, after graduating law school, taking the bar exam, I wanted to be with one of the top-notch firms in the state. And there were some firms that were in Houston. There were some that were outside of Houston. Honestly, I never thought I would find myself get a job at Abraham Watkins. It happened that they had a need. After I'd been practicing for maybe, I think, a year and a half, there was an opening for a temporary position here to work on one case. And so I really started as a temporary hire at the firm.
And how do you think you were able to achieve becoming a partner at such a young age?
So there was a lot of things that go into that, Geoffrey, and one of them was that I had good mentorship. There were goals that were set for us as associates, that if you want to be a partner one day, you have to do these following things. And so that was spelled out for me. Also working on some of the cases that I worked on, I got to learn from some of the best lawyers in the country. And so that was a great opportunity for me to work hard and kind of showcase just the hard work I can put in. And we had a very set expectation level that if you want to be a partner, you need to not only work your cases, you get results, you need to be board certified, you need to be a member of a BOTA, you need to try cases, and you have to try cases to get board certified as first chair. And you need to generate business, right? I mean, it's just the total package that you need. And so that was set out very clearly for me. That's just, to me, there was that was something I just needed to achieve. And so I set forth on achieving each of those goals as fast as I could, trying cases, getting board certified, at the same time working hard to build a referral network.
And to be clear, you are board certified in personal injury.
Yes, sir.
And what does it take to be board certified in personal injury?
You have to try a certain number of cases as first chair.
How many chairs are there?
Well, the first chair is the lead lawyer for
Okay.
the case, and then you can have second chair, and after that it doesn't count. But the key is that as the first chair, you typically will pick the jury. You will do the opening. You'll do the closing. You'll do a lot of the major events that happen in a trial. So there's a set number of trials you have to do as first chair. You have to take an exam, which is typically held in Austin, on your area of specialty, which obviously our area of specialty is personal injury trial law. So that's what our exam was focused on, is the type of cases that we work.
Okay. And I think we all know that you kind of work on a lot of high-profile cases. What was the first big case you can remember working on?
I think the case that kind of set the stage for my career was the West Fertilizer explosion case, a very tragic case. There was a whole community devastated in the city of West, which is north of Waco, Texas. This explosion was back in April of 2013. And it started off as a case where nobody thought there would be a recovery because the storage facility where the ammonium nitrate was being stored at the time of this fire and then explosion had only $1 million in insurance. So a lot of people, despite the massive death toll, the massive damage to the community, a lot of people just thought there was no case there. And so I had an opportunity. I got a case referred to me from a lawyer who works in Waco, and due to the fact that there was a vacuum, because people thought there was no case, we were able to find an angle and pursue it against the manufacturers of the ammonium nitrate. And then, given the complexity of that case, we got a lot of cases referred over. We had a big contingent of cases, wrongful death cases, and serious personal injury cases. And that case went on for several years and was extremely contested because there had never been a successful civil lawsuit against a manufacturer of ammonium nitrate in the history of the United States. I mean, there had been incidents involving ammonium nitrate. There had been industrial incidents. There had been criminal incidents like Oklahoma City, the first World Trade Center bombing. Those events involved ammonium nitrate, but those cases did not succeed.
Okay.
And in that case, we took hundreds of depositions. Very science-based case. It was based on a lot of expert work, a lot of document review, hundreds of depositions, and we were able to get our clients' cases settled first after the first couple of trial settings, and then we settled our whole group of cases.
Okay, and what kind of personal injury case was that? Was it a premises liability case? Was it a product liability case? Wrongful death?
So there were wrongful deaths in that case, but the true nature of the case was a product liability case.
Okay.
And because our allegations were, since the product was at a customer's facility and out of the hands of the manufacturer, right? They had shipped the product. And so we had marketing defect theories, which means that the dangers associated with the product had not been properly communicated to the end user. We had design defect theories, which meant that they could have added certain materials to the ammonium nitrate to make it inert in case of a fire. And surprisingly, what I learned in that case was that there's hundreds and hundreds of communities all over the state where ammonium nitrate is stored in the middle of the community, these farming communities, where you have tons and tons of material that really is an explosive material, right? It was used for explosive purposes in certain situations. That material is in the middle of neighborhoods. The West event was the storage facility was very close to the high school, the middle school, a nursing home, an apartment complex. So the first client that I represented was actually in the apartment complex. Next to the facility. It got destroyed. He got severely injured, had severe injuries, and ended up taking his own life because of the extent of his injuries. PTSD, and yes sir, and major scarring. He had major scarring. We also represented others in that apartment complex. But from my perspective, these the schools, the apartment complex, the nursing home, the storage facility should have never been within.
I was going to ask you that. Why do they put these explosive materials so close to all these residential buildings and people?
That's a great question. Because the parties that to the case, the defendants were, these are international companies, okay? And so one of them actually does business in Europe. And what we discovered in the discovery process of taking depositions of their executives, some of whom had worked in Europe as well, that they've had a different set of rules. So what they did here, they could not have done in the UK. Because over there they were not allowed to build a storage facility or actually sell to a storage facility that has wood storage, does not have sprinkler systems, and is so close to these buildings that have people in them, that was something that would not be allowed in per their own policies in Europe.
Right.
And frankly, I think that's what got the case settled. I mean, if the jury was to hear that they have two sets of rules,
right,
I don't think that would have gone well with the jury here. And even down to the type of storage. Over there you need to have a concrete bunker or some type of concrete walls that you store this material in. You need to have minimum distances from other buildings. None of that was being followed or implemented in Texas.
Wow. So you mentioned product liability on this case. A couple other ones I think you have are 3M, Takata airbag. Can you kind of explain what happened to Takata? Because I think West Fertilizer and Takata have a couple similarities.
Yes. So sometime after or during the West litigation, after there was an ongoing issue, there were fatalities happening from exploding airbags, and that had been actually going on for several years. And we got retained on a case where, unfortunately, a young woman in the Fort Bend area had been in a minor accident, very minor, and her airbag inflator ruptured when the airbag deployed and sent a piece of shrapnel into her neck, and she bled out and died at the scene.
Wow.
There was a nurse who tried to save her, but there was too much damage. And so when I started looking into that case, one of the first things that jumped out to me was that the material that was being used to inflate the airbag, to create the energy that would inflate the airbag, was ammonium nitrate. Which
Same
is
thing that blew up at the West Fertilizer.
the same material that exploded at West Fertilizer and basically destroyed the town. A lot more quantity in West, but the same material was, at some point, Takata had made the decision that they were going to start using ammonium nitrate as the source of energy in the airbag, that when it gets the signal from an impact, the electronic charge is supposed to energize the propellant, and that fills your airbag, right? And it comes out in your steering wheel, right? Interestingly, in the West case, there was actually some documentation where Takara had approached them and to manufacture. The manufacturers of the ammonium nitrate that was involved in West had been approached by Takara to manufacture ammonium nitrate for them, and they refused. They thought that this is not a proper application for this material.
Right.
And so
which makes sense.
Which makes sense, right? And they told Takara, even before they started this whole manufacturing process, they told them in a memo that this is not a proper application. Which it's not, because if you think about it, ammonium nitrate has an equivalency with TNT. It's an explosive material. It's not as powerful as TNT, but I think it's roughly around 0.4 is the TNT equivalency. So if you take 1 pound of TNT, and it detonates, you could roughly take 2 pounds of ammonium nitrate, and it would have the same effect.
Wow.
Okay, so what they've done is they've taken an explosive material and placed it in your steering wheel, and then they have encased it in metal, right? Which is kind of the same concept that you have when you make a grenade, right? Your fragmentation grenade is something that breaks apart when you have explosive inside of it. Right, those pieces of the grenade are what cause damage.
Right.
And so, an almost identical scenario here, where you have ammonium nitrate. It's fitted with a charge. The charge is linked to sensors in the hood of your car. And the concept was that the ammonium nitrate would let off energy, and that energy is going to expand your airbag, right? But over time, and this is something that's been known for decades, that over time, ammonium nitrate will go through what's called a phase transition. What that means is that as temperature goes over a certain amount, it has the chemical properties change. And when temperature comes below a certain number, the chemical properties change. And once you keep going in these phase transitions, especially in the south because of the higher temperatures in the summer, the material is going to start breaking down. And once it breaks down, it turns from something that would give energy to something that would detonate. And those detonations were what started causing the inflators, the metal inflators to rupture. And then the ruptured parts would act as projectiles within the occupant space. Okay? And so that had been going on for many years. And lawyers around the country had those cases. Once they started figuring out, what the unusual nature of the event was. But Takara had taken the position from the beginning with the federal authorities that they did not know what was happening. They called them these field failures and unknown reason. Okay, and so we got into the lawsuit with Takara and the car manufacturer and put out a very lengthy statement where, based on the knowledge that I had gained in the West Fertilizer case about ammonium nitrate, we were able to apply that to what had happened with the airbags. And we just laid it out. We said, hey, this is why this is happening. There's no mystery here. You have used an explosive material. This explosive material is in millions of cars, not just limited models, right? Because initially the recall started with just 1 year model or one make, but it's the same problem that's in all of these vehicles. So
different makes, different models. Porsche, BMW, Mercedes,
Honda, Toyota, Mercedes, everybody at some point in time if they bought airbag systems from Takata, have those in the cars. They have ammonium nitrate.
Right.
And
Takata was told by the people in West Fertilizer, don't use this.
the manufacturers of the ammonium nitrate,
Right.
Had told them way in advance. Their own testing showed that they were failures, but they hit those tests. There was some testing done in Japan which never came to light until a lot later when there was a whistleblower. But we approached that case from that angle, and almost instantly there was widespread outcry about what had happened or what was happening, because at some point everybody, once you read our press release, listened to the interview, read up on the material, everybody was concerned that there's like a hand grenade in their car, right? And people started calling their dealerships, calling their local politicians, asking what's the fix here, because within a few weeks of our press release and lawsuit being filed, Takata expanded the scope of their recall and then kept on expanding it until they then filed for bankruptcy.
Right.
And that case got resolved. Unfortunately, our client was deceased, but that case settled within a few months. But from there on, I think that kind of set this ball rolling on people questioning Takata's knowledge, which ultimately led to them trying to replace some of them, but they just don't have enough parts to replace them, right? And so they just filed for bankruptcy.
So now they're gone.
They're gone, but the inflators are still there.
In multiple cars.
In several cars.
Okay. And
millions.
Then is there any recourse for those people? Can they go after who used to own, or since Takata was a subsidiary, who owned Takata?
So Takata used the bankruptcy process to absolve themselves literally of this problem. The only recourse that people would have is against the manufacturers of the vehicles.
Okay.
The people who, like the Toyotas, the Hondas of the world, but that's still limited. So the way that bankruptcy, and it's very complicated as to how it all came about, but there's limited recourse for people, not like what it used to be.
But these airbags are no longer allowed to be put in vehicles, right?
Moving forward, okay. And they just did this because of profits. It was a cheap material. It was a cheap propellant. It's mass produced.
Okay.
It used to be used for agricultural purposes, so it's mass produced. So it's
Is it still around? Do they still use it for agricultural purposes, or is it kind of
very limited?
Okay.
Very limited. So there's after the West event, there was a lot of spotlight on the industry, and OSHA made some new regulations onto fire rating of buildings. That means how long can a building where you're going to sustain ammonium nitrate, how long can that withstand a fire? A lot of light was shed on letting first responders know what the dangers are of this product. If you're going to respond to a fire in an ammonium nitrate facility, how to proceed with that. Because nobody really understood the dangers. Generally, the public did not understand the dangers until the West event happened.
Gotcha.
Nobody thought that ammonium nitrate could explode under those conditions, other than there had been explosions under those types of conditions, and the manufacturers were aware of that.
Gotcha. So I think another product liability case we have in-house here, a lot of people don't know, is 3M. A lot of veterans have been injured, lost hearing through 3M earplugs. A lot of people think of 3M as people that make vehicle wraps, they make stickers, they make tabs on their binders, but 3M actually makes earplugs for veterans. Can you kind of explain that case that's going on?
Sure. So that case is a product liability case. It's what's considered a mass tort, which means there's hundreds of thousands of cases. 3M has become into the biggest mass tort in the history of the United States, numbers-wise. The biggest or one of the biggest. Basically, it goes down to there's a company called Aero Technologies that was awarded a contract to make hearing protection for the military, for the troops, and it was supposed to be the type of hearing protection that could be used for multiple purposes, and it was improperly designed from the get-go. It's kind of similar to our Takata situation, in a way that from the get-go they knew that this is a bad idea. Aero did.
They did it anyway.
Aero Technologies knew, but failed to act. They got a big government contract, sold millions of these units. Aero got purchased by 3M at some point, along with that, all the liabilities that went with that. And so the 3M case has been ongoing. We are honored to represent thousands of veterans in that litigation. There's been 17 trials so far. The majority of the trials, the jury verdicts have come in favor of the plaintiffs, the veterans. 3M has tried to put Aero into bankruptcy. Again, trying to use the bankruptcy law for a purpose that we believe that the bankruptcy law was never meant to be used for, right? To absolve yourself of liability. I mean, that's just not what the intent of the bankruptcy process is, but that's what some lawyers have come up with, an idea that you could divest yourself of you can create an entity and put it in bankruptcy and give them all your liabilities. It's the very basic way to break it down. There's a lot of controversy about that.
But basically make a whole bunch of profit up front doing something you know is wrong, and then if something happens, hey, we'll just file for bankruptcy afterwards. Basically,
and there's more steps that go into it, but we have been able to stall their efforts so far, and so the case is still on track, and hopefully, at some point we can get a resolution for the thousands of clients that we represent.
Okay. Earlier, right there, you just talked about mass tort. Can you kind of quickly summarize the difference? Because a lot of people think you have a mass amount of people filing a lawsuit, that's class action. What's the difference between class action, mass tort? I think I've heard before from some of our chemical plant explosions, those are MDLs. Can you kind of quickly say the difference of those?
Sure. So really, there's three, the way I would classify it, there's a mass tort, which is where there's thousands of people that have been affected by a product, usually a drug or a medical device, or like in 3M's case, hearing protection. Okay, that's mass tort.
Okay,
but they've been injured at different times.
Okay, so
everybo's
not
used
a single event.
Not a single event.
Okay,
they've been injured at different times when they used the product or they took the drug. The class action is something totally separate, right? Which is not suitable for those type of cases, in my opinion, because you have to have individualized damages. Okay, what we really specialize the most in is what I call a mass casualty event.
Okay,
where you have an event where there is numerous casualties, fatalities, injuries as a result of one event.
Okay.
Such as West Fertilizer, such as the MGM October 1 shooting. We just had the anniversary here recently. So that's one event, and both mass torts and mass casualty events usually get put in what's called an MDL, multi-district litigation. You could have a state court MDL, you could have a federal court MDL. 3M is a federal court MDL. Some of these other cases that we're involved in, where there's been a massive explosion or a fire, and there's multiple fatalities or injuries, are in state court MDLs. And so over the years, over the last 5 years, I've been involved in many MDLs. I've actually been either lead counsel or liaison counsel or co-liaison counsel on several MDLs, where we prepare each case individually as if it was going to be tried either by itself or with one or two other cases. But they're in this MDL setting where there is organized discovery and depositions, and there's rules that relate to promote the efficiency of the process. Because there's 10, 15, 100 different law firms involved.
Right.
So the court's not going to allow each of the firms to take 100 depositions of the same person.
Right.
So they have to be organized, and the plaintiffs need to organize and typically, ideally, utilize their resources and time and expense money in a way that benefits the group. And so I found myself to be heavily involved in MDLs, and I think we have a really good track record in MDLs. Part of that being, we work well with other firms. We try to treat everybody fairly and just take the lead in working up the case, right? And so very different from a class action.
Okay, so Vegas was an MDL since it was a one-night mass casualty shooting event. Now, we obviously didn't go after the actual shooter. We went after the property that allowed the shooter on premises, correct?
So the shooter was part of the case.
Okay.
The shooter had died in the event, but given the enormity of the loss and the circumstances under which the shooting happened, there was a strong belief and evidence that MGM had liability for the event, and so that was the avenue that was focused on.
Okay, and then throughout that lawsuit, were we trying to prove that they should have had better cameras, they should have had more security, they should have been more observant? Kind of what were we going after MGM for on that?
So there were multiple areas in that case that we were focusing on. Okay, one was how that event itself played out and the timelines of things, and how the shooter was able to get that much ammunition, those many guns, with the help of the staff, really, up into his room.
Oh, okay.
Using a staff elevator. But then there was a big picture issues as well as to security at these facilities, right? There's ongoing threat of terrorism. There was some evidence that they had been notified that there needs to be more security. The basic things like bomb sniffing dogs or canines. You should have canine units, something like that. Would have easily prevented this event. So that was really a security case.
Okay, so that was MDL, and that had thousands of people involved.
4,000.
Okay, and then we also have some other MDL cases that we kind of specialize here in, because we're in Houston, all these chemical plants. We have a lot of safety issues going on. I know right now we're currently in a lawsuit with Citgo, with we finished Carrari. We're working on Westlake in Louisiana, but their corporate headquarters is in Houston. Can you kind of touch on those cases as well?
Yes, sir. So, obviously we're being in Houston, we're close to a lot of chemical plants, refineries, and what I've learned over the course of years working on these cases is that over decades of experience, there's been rules set that need to be followed to protect refinery workers. Right? There's permits, there's air atmospheric checks, what we call LEL checks. There's line break procedures. There are H2S procedures, the confined space entry procedures. There's a lot of procedures. The problem is when people stop following those procedures. And Usually, in a number of these cases that you mentioned, Geoffrey, the problem happens during or towards the end of what's called a turnaround. Unit shut down, repair work's being done, and most of these incidents happen during a shutdown because the plant owner wants to get back into production.
Right.
Because if this unit shut down, you're not making money.
Right.
No production going on. And so most of these incidents happen either during or really towards the end of the shutdown when they're trying to do multiple jobs at the same time. Okay. So to give you example of one of the cases we have going on in the Westlake chemical litigation, there's a thing called simultaneous operations, SIMOPS. Two different contractors working around each other at the same time. That can create a lot of risk for people if there is not good communication. If one person is doing work that would create potential of release of hazardous material,
right,
another person 15 feet from them is starting to weld,
but they work for two different
contractors. So if the simultaneous operations procedure is not being followed, there's going to be problems, right? And people are being rushed. I mean, it sounds kind of cliche that it's always rush, but in most of these cases, that's what we find out.
I was going to say, a lot of these cases that we've been talking about, everything comes down to profit a little bit, or a lot of it.
A lot of these decisions, poor decisions, are made because people are trying to rush things, and they're just trying to make things move without going through all the safety steps, without doing all the LEL checks, without trying to figure out if there is an abnormal condition in the system, what's the source of that condition? Okay, instead of saying, hey, just burn it off to the flare and proceed as usual, right? Because during a turnaround, a system is shut down.
Right.
It's supposed to be blocked, blinded. No material should come into the system. And if there's any indication that there's new material in the system, for example, in one of our cases, several injured workers got burned. There was an abnormal condition, and instead of investigating the abnormal condition, the plant owner decided to release any material to the flare, and the flare is what you see burning at night. If you drive by Pasadena, the fires are coming out of those pipes. That's the flare. So they burned it off and then told our clients, to proceed with their work. Well, the fundamental question that should have been addressed at that point is, why is there pressure in a system that's been closed for 3 days?
Right.
Okay. That was never addressed. Basic common sense. It resulted in a fire and severe burns to our clients. Completely avoidable incident.
Right. They've just been a little bit slower and been safe about it.
Correct.
Okay. So that's kind of what we kind of saw in, I think Ferrari was a big emphasis on safety or lack of safety, because there was a lot of alarms that went off.
So there was a lot of issues with that case. Initially, what they were trying to say was this is operator human error.
Okay.
So pressures were rising in the reactor, and alarms were going off, and one operator just missed it, and so that was the initial story. Well, the story went a lot deeper than that. And it went back years and years and years. The system that they had there on that reactor was the pressure relief system that they had. In case there would be an abnormal buildup of pressure, then instead of the entire reactor just exploding and killing hundreds of people, they're designed, which has happened in the past, right? So, people try to learn from their mistakes. 50 years ago, 80 years ago, engineers started putting pressure relief systems on reactors.
Right, okay.
So pressure builds up, system's supposed to relieve.
Okay.
That's what happened here. But the pressure relief system was very outdated and caused a consequence which they had been told about. This could happen. This could injure or kill people. And certain proposals were provided to them by third-party contractors on how to fix that, and they decided not to.
Okay.
Because it was going to cost them a certain amount of money. And so somebody in Japan made the decision that no, we don't need to do this, and so there was notice, years of notice, that led to that incident.
Profits again. Is that kind of what happened with our current case with Watson Grinding? Because I know a lot of people hear the name Watson, they might not know, but for anybody listening, Watson Grinding, we were on Houston. Watson Grinding's way out by the Beltway. 4 a.m. you hear an explosion. The whole city heard it. Just woke you up out of your sleep. Is that kind of the same thing that happened with Watson Grinding?
So Watson Grinding is a slightly different situation, as in it's not a refinery, right? So the Watson facility is thermal spray facility. It's an industrial facility, but they're not like a chemical plant.
Okay.
They don't have those type of systems and procedures. And what we had there was, again, multiple parties over the years, multiple missteps.
Okay.
And we all remember what happened that morning, and we have another neighborhood that was destroyed. That case is still ongoing. We've taken a lot of depositions, hundreds of depositions. And there is similarities for sure between what happened there and some of these other incidents.
Okay. Yeah, I know we can't talk much about it, but just wanted to kind of hit on that a little bit. Shifting gears a little bit, I know you were recently in trial a couple months ago for dram shop. A lot of people don't. Dram shop is where you somebody is out at a bar or restaurant. They're drinking. They go out, hit somebody. Most people get a DWI is what most people think of. Okay, DWI, that's it. No, actually, the establishment where the person was drinking can be held liable for their actions. Over-serving drinks to that person, they go out and injure or kill someone. What kind of happened in that case that you tried? Because I found it pretty interesting because it was multiple establishments that were over-serving this person.
So we tried this case earlier this year. The case dissolved during the course of trial, but one of the interesting things that I talked to the jury afterwards, and overriding concern that some of the people had. There was one lady who was a nurse, and what she shared with us after the case was over was that the sheer amount of DWI related injuries or intoxicated driving injuries, deaths that she sees every night in the ER is just overwhelming. And it just gets worse when we get closer to the holiday season. But it sounds like still, every time you put on the news, there's some wrong way driver, somebody's killed, a family, innocent people getting killed. Our case involved an innocent Uber Lyft driver, and who was hit by a drunk driver, and there was also a fatality in that case.
Our client was driving the Uber.
He was working.
He was working for Uber.
We're working for Uber. He was bringing somebody from the airport, just going down the road, minding his business, following the laws of the state of Texas. And along comes a driver at a very high rate of speed, and just plowed into them. And very graphic body cam footage we had from the scene, but basically the driver who hit them had been drinking at 2 establishments that night, and was, I believe at that time had just turned 21. And what we were able to accomplish in that case was that we got the footage, surveillance footage from bar number 1, where he'd had a very excessive amount of alcohol served to him. Almost 14. There was some controversy, I think, whether there was like 13 or 15 drinks. Okay, well,
for one person.
Yeah, that was a point of contention. But we then had left that establishment, gone to another establishment.
Right.
Interestingly, somebody in the case tracked his movements through the phone, or the DA's office did, And even leaving the first establishment, going to the second one, he was doing like 90, 95, 100 miles an hour on I-45.
So already heavily intoxicated from being overserved at the first establishment, walks into another establishment.
Goes to another establishment. There was proceeded to be served with something that was equivalent to 5 shots in a course of like a span of 33 minutes or something like that. Okay. Leaves there and then kind of drives around in circles towards GPS showed and stops at in a church parking lot at some point, then leaves at a high rate of speed and causes the crash. Right.
Wow.
So under the laws of the state of Texas, if you're going to sell, you need a license to sell liquor commercially.
Correct.
Right. And with that license, you get the right to sell liquor, but with that right, you get some obligations too.
Right. You have responsibility.
Right? Responsibility. It's just like being a firearms owner. You can go buy a gun, but there's also responsibility.
Right.
Similarly, if you are going to profit from selling alcohol to the public, then there's a set of rules you have to follow, right? And if those rules are broken, then you can have civil liability for any injuries or death that is caused as a result of overservice. And the law in that area is very complicated. It's frankly very favorable to the industry, the entertainment industry, or the alcohol service industry. But if you have the right circumstance, you can hold them liable.
Okay.
And in that case, we did a lot of what I think is kind of innovative work. Is we not only looked at the service to the person who had caused the incident, we looked at the service to everybody that night who was at the restaurant.
We have camera footage of the servers.
So we got the camera footage of the entire restaurant / bar. We got the receipts for everybody. And our investigator basically sat there and watched hours and hours and hours of footage and added up who had been served what at every table.
Wow.
And there were multiple tables that had overservice, multiple tables. And that was a problem for them.
So this is just baked into their culture that they overserve all their patrons.
Right. It wasn't just one rogue server, right? Not just one guy not following the rules. Multiple tables.
Right.
The manager not doing his job.
Right.
Okay. Manager young, inexperienced. And again, that was a big point of contention, whether that's admissible, relevant, all of those things. So I think we do know that as a result of that incident, there were some positive changes made by that chain, and as to how much could be served, and when the system itself, the software was installed, that you just couldn't exceed a certain limit. And so I think big picture that overall promotes safety, but overservice of alcohol related deaths is a real problem in Houston.
Right. I think I saw a stat that said Houston is the #1 market right now for DWI cases or deadly traffic accidents in Texas. So definitely need to be careful about that. Last thing I want to kind of touch on is it's a very sad story. Emery Sayer. This is a new case we just received. Can you kind of go? I know it's ongoing, so I know we can't talk a lot about it. But can you kind of share a little bit about what happened in this event?
Sure. So it is a very tragic case. We represent the parents of a minor, a child, a girl who was dropped off from her school bus and then got tragically run over by the school bus, and killed. The big picture issue for me in that case, because I got the case, I looked at it very closely to see what is it that we want to accomplish and what does the family want to accomplish here. And school bus safety is a huge issue. Unfortunately, kids have been getting run over by school buses for as long as school buses have been around, right? So over years, there have been changes made. There was a huge fight about seat belts like a decade ago. The industry the industry did not want to put seat belts for the kids, right? Huge fight about that. Again, in other countries they do, but that was one point of contention. The issue in this case is blind spots.
Okay.
So you got a bus driver, he or she is sitting up there. You know that kids are going to behave unpredictably because they're kids. Right? And you being the industry, the bus manufacturers know that they're blind spots, right? So just like you have a camera in your car when you reverse, if somebody gets close to the car, all sorts of beeps and buzzers go off.
Right.
There should be the same safety features in a school bus. Because who else would you want to protect more than these kids?
Right, exactly.
Right?
And some school buses do have.
Yeah.
Some school districts mandatory have built that into their purchase of school buses. They'll have cameras, blind spots.
Yes. So, there's not a national regulation, like it's not uniform.
Right.
So different school districts will do different things.
Okay.
Some will have these features, some don't. But from my perspective, why not just have these features as a standard feature, right? Your car has these features as a standard feature. Mine does. Why wouldn't we just have that?
Exactly.
Why would it even be something that's left up to debate and the budget of some school district depending on their size or whatever, or it should be a standard feature. So I feel that case is going to be very hotly contested, and again, our hope is to bring some awareness and change to the industry.